Section 482 of BNSS 2023 is now anticipatory bail. Let's read the section language. Direction for grant of bail to person apprehending arrest. 482 1. When any person has reason to believe that he may be arrested on an accusation of having committed a non-bailable offense, he may apply to the High Court or the Court of Session for a direction under this section, and that court may, if it thinks fit, direct that in the event of such arrest, he shall be released on bail. 2. When the High Court or the Court of Session makes a direction under subsection 1, it may include such conditions in such directions in the light of the facts of the particular case as it may think fit, including I. A condition that the person shall make himself available for interrogation by a police officer as and when required. 2. A condition that the person shall not, directly or indirectly, make any inducement, threat or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or to any police officer. 3. A condition that the person shall not leave India without the previous permission of the court. 4. Such other condition as may be imposed under subsection 3 of section 480, as if the bail were granted under that section. 3. If such person is thereafter arrested without warrant by an officer in charge of a police station on such accusation, and is prepared either at the time of arrest or at any time while in the custody of such officer to give bail, he shall be released on bail, and if a magistrate taking cognizance of such offence decides that a warrant should be issued in the first instance against that person, he shall issue a bailable warrant in conformity with the direction of the court under subsection 1. 4. Nothing in this section shall apply to any case involving the arrest of any person on accusation of having committed an offence under section 65 and subsection 2 of section 70 of the Bharatiya Nyaya Sanhita, 2023. Anticipatory bail. Anticipatory bail is like a legal safety net, an option sought before an actual arrest occurs. It's particularly useful when someone fears being arrested based on false or fabricated charges. Now, let's break down the key points from section 482 of the BNSS. Anticipatory bail and section 482 BNSS. What is it? Anticipatory bail allows an individual to seek protection from arrest before it actually happens. Where can you apply? Applications for anticipatory bail can be filed with the Sessions Court, High Court, or even the Supreme Court. Section 482 1 BNSS. If someone believes they might be arrested for a non-bailable offense, they can approach the High Court or the Court of Session. These courts have the authority to issue a directive under this section, stating that if the person is arrested, they shall be released on bail. Conditions imposed by the court. Section 482 2 BNSS. When the court issues a direction under subsection 1 of section 482 BNSS, it can impose specific conditions relevant to the case. These conditions may include making oneself available for police interrogation as needed, not influencing, threatening, or promising anything to anyone involved in the case to prevent them from sharing information with the court or police, not leaving India without prior permission from the court. Any other conditions outlined in subsection 3 of section 480, as if bail had been granted under that section. Release on bail, section 482, 3 BNSS. If a person with anticipatory bail is subsequently arrested without a warrant by a police officer, they must be released on bail if they offer it at the time of arrest or while in custody. If a magistrate later decides that a warrant is necessary, they issue a bailable warrant following the court's guidelines. Exceptions, section 482, 4 BNSS. The provisions of section 481 for anticipatory bail do not apply to cases involving offences under section 65, 2 BNSS. Rape on a woman under 12 years of age. Section 70 BNSS, gang rape. Changes introduced by the BNSS. E2 BNSS. The BNSS removes several factors that were previously considered by courts when deciding anticipatory bail applications. These factors included the severity of the alleged crime, the accused's criminal history, and the likelihood of absconding. Additionally, the BNSS eliminates the requirement for the applicant seeking anticipatory bail to be present at the final hearing and the issuance of the order. One notable case that exemplifies the application of anticipatory bail provisions under the Bharatiya Nagarik Suraksha Sanhita 2023 BNSS is the Rajesh Sharma vs. State of UP case. This case, decided by the Supreme Court of India, clarified certain aspects related to anticipatory bail. Here are the key takeaways from the Rajesh Sharma case. Background: Rajesh Sharma, the petitioner, sought anticipatory bail after being accused of offences under section 498A, cruelty to a married woman by her husband or relatives, of the Indian Penal Code, IPC. The case raised questions about the misuse of section 498A and the need for safeguards against arbitrary arrests. Observations by the Supreme Court. The Supreme Court acknowledged that while Section 498A was enacted to protect women from cruelty, there were instances of its misuse. The court emphasized the importance of balancing the rights of the accused with the protection of victims. Guidelines issued by the court. The court laid down guidelines to prevent misuse of Section 498A. Family welfare committees. It recommended the formation of family welfare committees at the district level to scrutinize complaints before arrests. These committees would assess the veracity of the allegations. No arrests without investigation. The police were directed not to make automatic arrests based solely on the filing of a complaint under Section 498. Instead, they should conduct a preliminary inquiry. Anticipatory bail. The court reaffirmed the importance of anticipatory bail as a safeguard against arbitrary arrests. It emphasized that anticipatory bail should be granted unless there are compelling reasons to deny it. Impact and significance. The Rajesh Sharma case highlighted the need for a balanced approach In cases involving Section 498A, it underscored the role of anticipatory bail in protecting the rights of the accused while ensuring justice for victims. Remember, each case is unique, and the court's decision depends on the specific facts and circumstances, but the Rajesh Sharma case serves as an important reference point when discussing anticipatory bail under the BNSS.